Alright, so this is disrespected parent, Suffolk County. One more time. I'm going to read to you a decision from Judge Rouse regarding his recusal that he denied. The respondent's motion for recusal is in all respects denied. The respondent's basis for the motion are factually and or legally incorrect and provide no justification for recusal of this court. That is the decision dated December 16th, 2014. Okay. Now, my motion for recusal reads, that on June 12, 2014, at the conclusion of a hearing, Judge Rouse issued an order of protection, states both parties present in court. It states, in quotations, it actually reads, this is the actual order of protection, and it's dated June 14th, 2014, with Judge Rouse's stamped signature. On top, both parties present in court, and down here it reads, a petition under Article 10 of the Family Court Act having been filed on May 19, 2014 in this court, and after hearing an order, and Duncan Bruce Ross having been present in court and advised of the issuance of contents of this order. Okay. Present in court on June 12th, 2014. Transcript dated June 12th, 2014. Page 2. Page 2, or I'm sorry, page 3. Lines 2. I understand the court has waived the respondent's appearance as he is currently incarcerated and will be for the foreseeable future. Okay. I understand. You can read it for yourself. 6/12/2014. I understand the court has waived the respondent's appearance. Okay. So there's no way I can be in court when the order of protection was issued. Now, further, there is another decision dated, it was actually mailed to me on August 30th. In response to a letter I sent the judge. And that is brought up. Respondent sent the letter to Judge Rouse dated August 7, 2014, which informed the court that respondent filed a second order to show cause for visitation while he's incarcerated. In response to this, respondent received an envelope dated August 30th, which contained an order dated May 30th, 2014. This order stated that the order was given to petitioner in parties counsel in court. Okay, so here it is. The order dated May 30th, the envelope. And down here it states that order was in court given to petitioner to parties counsel on 6/12/2014 by COSCDD. Okay, Part 9. That's, again, an impossibility, as we just previously already showed that I was not in court. Now, further showing his bias and prejudice and everything else, I bring up the fact that without me being produced on August 28th, the judge held another date that goes in. Respondent never appeared in court. Respondent was served with the county. Okay, without respondent being produced to the courtroom, the court put this matter over till September 23rd for decision. Okay, the fact that the court was aware respondent was in the courthouse but did not have him produced for this conference impacted respondent's ability to place on the record his need to time to reply, as well as the fact that he believed he was illegally served papers by a party to the action. This willful action by Judge Rouse violated respondent's due process rights. Okay, all these things violate my rights. Now, with regards to the August 28th transcript and the subsequent decisions, this is August 28th. (2014) transcript, and it states on page 2, lines 13 through 19. Oh, yeah. I'll read it to you now. But that's the transcript, and I'm going to go ahead and get it read to you here. The court, alright, Mr. McClancy is not here. He's in another courtroom at the moment. However, this is on for motion. Mr. Bruce Ross has appeared in this courthouse today and has been served with opposition papers from Mr. Burnett and Ms. Daly, and whether or not he chooses to file a reply is up to him. But the matter is put on for September 23rd for decision. Okay. Now that's for my violation, or to dismiss the actual paperwork. Now, I was given the opportunity. I filed my extension. I requested a time for extension. By doing that, what I received was this decision. And the decision is mailed to me. Received it September 16th, 2014. This decision to me in jail. Okay. And this decision is dated August 28th, 2014, signed by Judge Rouse. The same day, he said that I had the opportunity to file a response by September 23rd. So, I sent an extension of time to reply to motion dated September 13th, 2014. This was received by the court on September 15th. We'll get to that. Showing this one, which was mailed to me on September 16th, was actually mailed to me after my request for extension of time to reply was received by the court. Why a decision dated August 28th took so long to get to me, I don't know. But in this, it says, the county attorney, by Assistant County Attorney James G. Burnett, has submitted an affirmation in opposition dated August 18, 2014. The attorney for the child, Jill Daly, Esquire, has submitted an affirmation in opposition dated August 27, 2014. Therefore, August 27th and August 28th, there's no way for me to be served with any paperwork to even make a reply, let alone a judge making a decision. Order that the respondent's cross motion to dismiss the petition is in all respects denied. As dated August 28, 2014, answer Judge Rouse. It's clearly intended to violate my rights by doing so. Now, as that said, that's part of my recusal, is that he did that. But with that said, it is a decision dated September 19th. Okay. Now, put in the case over to 23rd now. Also, in reply to respondent's motion for the extension of time to reply, respondent's responsive motion to dismiss the court mailed Exhibit 1 decision dated September 19th. This decision states and claims, on August 28, 2014, this court rendered a decision on the motion. Now the respondent on September 15, 2014 has filed a request for further time to submit a reply to answer submitted to this motion. This application is denied as untimely and mute. Insofar as the decision has already been reached, this decision with the alleged decision made on August 28, 2014 shows the continued violation of respondent's due process rights along with the continued violation of the aforementioned rules. Now, by citing the fact that my paperwork was received on September 15th, it is clear, not only is the court aware that I filed my request, but it acknowledges receipt on September 15th, the day before the August 28th decision was mailed to me. However, this decision is dated September 19th, 2014, mailed to on September 22nd, 2014. Proof of that is the envelope that it was received in. Okay. For whatever reason, this decision dated September 19th is the very first decision that I received within 3 days of it being issued, showing that the court has no problem getting decisions out when they're made timely and correctly. The fact that an August 28th decision was not mailed to me until September 16th only shows that it was made after they received my request. There is no other explanation if they can get a September 19th decision out to me 3 days later. There's no excuse for the delay in receiving every other decision. So, with that, it's very clear that this judge has made very obvious rulings in bias against me, and his impartiality has reasonably been put in question. Now, that's documentary evidence as shown in this video. The judge's decision again states the respondent's basis for the motion are factually and or legally incorrect and provide no justification for recusal of this court. Now, if anybody would like to look up the laws of the state, New York NY CPLR 100, or I'm sorry, not CPLR, New York NYCRR. So actually, violation 22 NYCRR sections 100.1, 100.2, and 100.3 are all violated and require the recusal. Further, his violations have committed felonies and misdemeanors, in such as the criminal penal law, New York State Penal Law 175.35, offering a false instrument for filing by presenting 2 orders to the court that could not have been made in my presence as claimed for June 12th, 2014. Also, conspiracy under Penal Code 105.05 in the 5th degree for going along with the hearing on June 12th, knowing that I was not there, but yet still committing the felony. Okay? These are very clear-cut violations of the code of conduct, the ethics, but yet he claims that they are factually and or legally incorrect. You tell me, because you saw the evidence here. Again, I could be wrong. I could be making everything up. But these decisions were made and part of my family court file. It is indisputable evidence of the level of corruption that I have dealt with. Disrespect the Father. Signing out.